Hi, I'm firearms attorney Gilbert Ambler, and I'm back today with a question that I frequently get asked. People will call my office having recently been convicted of a felony, and they want to know what options are available for them either to defend themselves or even to hunt with. And we're going to talk this through today because I want to point out some distinctions. And at the outset, I want to let you know what we're talking about is predominantly federal law, and we might discuss some things specific to Virginia, but I cannot give you advice on every state. Every state is going to have their own restrictions for felons and people that have been convicted of certain crimes on what they can and cannot possess. You need to talk to a lawyer who's knowledgeable in your state who can advise you with respect to your state. So again, I'm giving you general advice based off federal laws. This is not specific legal advice. If you're in this position, talk to a competent lawyer, but I'll give you some things to think about here. And before we dive into this subject, if you have not yet hit that subscribe button, what are you waiting for? Hit subscribe, like, comment with your thoughts, share with your friends. That way you and your friends can keep getting this important Second Amendment related content. So the first category, or the first thing that I want to talk about, is the distinction between somebody that is still on court supervision, so probation or parole for states that have parole, versus somebody who is simply a convicted felon who's not on probation, not on parole, not subject to court supervision. If you are still subject to court supervision, there's very likely a condition that says no weapons. You will have also incidentally probably given up your Fourth Amendment rights, meaning your probation officer can show up, search your house, and you can't have weapons. Weapons is a far broader term than firearms, okay? So once you are done with the conditions of probation or parole, again, contingent on your state laws, you will likely be able to own some things that might properly be classified as weapons, provided they are not firearms, because federal law prohibits you from possessing firearms if you have been convicted of a felony. And it's important to note, not only does federal law prohibit you from possessing firearms, it also prohibits you from possessing ammunition. And when I talk to people in these situations, I very strongly urge them to get rid of firearms accessories, because if somebody shows up, searches your house, and they find a holster and a streamlight that attaches to a firearm and maybe a couple different holsters and some slings and some ammo boxes that don't have ammo in them, they are going to think that you are in violation of these conditions or in violation of these laws. So my advice is, if you can't possess firearms, you also can't possess ammunition, and then be smart and get rid of the accessories at the same time so that there's no confusion on this. However, once you're done with all the conditions, you're a convicted felon, and you're trying to figure out what weapons you can possess, there's several categories under federal law that you can and should consider. The first would be air guns. Air guns have gotten very, very good recently, and they are not firearms pursuant to federal law. So you could have, under federal law at least, there's air guns made for hunting that have pretty impressive muzzle velocities. There's also air guns made for personal defense, things like the Byrna. The Byrna, of course, is a pepper ball launcher. It also shoots kinetic rounds, not through the action of an explosive, but through compressed air, which is why it is not a firearm. Other options, and these are sort of more traditional, you could consider whether your state would allow you to have pepper spray or a taser. Again, federal law would allow you to have a taser. Many states, including Virginia, have restrictions on tasers, but it's something that you could look at. The next category that I think you ought to, in all fairness, be considering is antique firearms. And again, state law differs on this. In Virginia, for example, violent felons, if you were convicted of a violent felony, and that category is broader than you might imagine, but violent felons cannot possess black powder firearms. So black powder and antique firearms often are grouped in together. They're things that fall outside the definition of a traditional firearm under federal law. And these get split into different categories. First category that we split things into is going to be a antique firearm that is a true antique. And what I mean is this firearm was actually made pre-1899. So it's a 1873 rifle or an 1885 handgun. 1898 or before is when it was made. And we don't care what ammunition it takes at that point. It is an actual antique, and therefore it is not a firearm under federal law. If it is a replica, if it is a pre-1899 design, but it was made in 2024, it is a replica firearm. And then you can possess it under federal law, provided that modern ammunition, modern fixed ammunition, is not available in commercial streams for it. So it has to be something where you can't easily have modern ammunition. It can't be readily convertible to take modern ammunition either. So that's a much more dicey category. But antique firearms are something that you should consider. Other weapons, crossbows, compound bows, etc. If you're a hunter, these are weapons. They're obviously not firearms. They are still permissible for you to own. And then the final thing that I frequently will get asked about is I'll get asked about other loved ones in the home having firearms. So my spouse owns a gun. I've been convicted of a felony. Can my spouse keep her firearm? And again, my advice is if you are subject to conditions, those conditions are probably broader than the law. So the conditions, meaning you're still on supervised probation, etc., conditions as no weapons in the home, your spouse, if they keep a firearm in the home, is putting you at risk of violating the terms of your conditions and potentially putting you back in jail. Once you're not subject to conditions, then yes, your spouse, generally speaking, can still possess firearms. They don't lose their rights simply because you lost your rights. However, they need to be very, very diligent at making sure that when they are not physically carrying a firearm, that they are putting it in a safe along with the ammunition in the safe. I recommend a biometric safe. That way you can prove that your fingerprints as a felon don't open the safe and only your spouse's fingerprints open the safe. And by the way, if there's ever an issue with this and law enforcement is looking into it, they are going to probably fingerprint the firearm. So you need to make sure your fingerprints are not on the firearm. You can't just once pick up the gun and play with it and mess around with it and then put it back in the safe. Do not touch it. It's your spouse's. Your spouse has Second Amendment rights. You do not have Second Amendment rights. Speaking of Second Amendment rights, the final thing as a felon that you should, in all fairness, consider is there a process in my state to restore gun rights? Can I go through and get an expungement? Can I get a pardon? Can I have my rights restored? Here in Virginia, my firm does a lot of gun rights restorations. It is a process that once you are no longer subject to probation, again, in Virginia, we don't have parole anymore, but once you're no longer subject to probation, if you get your civil, your voting rights restored, we can, in most cases, help you get your gun rights back. And then guess what? Then you would be eligible to have actual firearms again, and you wouldn't have to worry about all these alternatives. If you enjoyed this content, go ahead, give us a subscribe. Until next time.